Good afternoon. This is Daryl Gay from Aaron Fox and a fellow in the College of Labor Employment Lawyers. I welcome each and every one of you to the program today. This is the third in a series of seminars that are being put on by the COVID Task Force for the college. This one, as you know, is going to be regarding opportunity for us to have a dialogue with Commissioner Victoria Lipnic. And we, just so you know, we have one scheduled the next Tuesday, the 28th, which is going to be on virtual arbitrations. So the plan for the day, everybody, is we're going to have a chance for the commissioner to spend a couple minutes telling us some pearls of wisdom that she thinks might be important for us to know as we all deal with the pandemic issues. And then we're going to have the facilitators who represent management, union, and the plaintiff bar confront her with several queries about the issues that they're all dealing with and trying to advise their clients. Now, if you have any questions, you can use the chat, or I think it's the question button feature. Although I will warn you, we've developed a very extensive list of queries, so I will not guarantee we'll get to answer every question submitted to us. And the last thing is note that there is ability for you to get CLE credit. On the form, there's a list of handouts, including a PowerPoint prepared by the commissioner and several things regarding the pandemic guidance issued by the EEOC. And there's also a CLE form, which towards the last couple of minutes of this program, I will interrupt the program to be able to give you the necessary code to verify the fact that you, in fact, attended all of this program. We probably should do one at the beginning to make sure you're there in the beginning and the end, but right now it's only done at the end. Having said that, it's my pleasure now to introduce Commissioner Victoria Lipnic. Commissioner Lipnic has been with the Commission of EEOC since 2010 when she was appointed by President Obama. She was then reappointed back in 2015 and for a while served as acting chair of the commission for 2.5 years. Prior to that, Commissioner Lipnic served as a U.S. Assistant Secretary of Labor for Employment Standards, which oversaw the Wage and Hour Division, the Office of Federal Contract Compliance Programs, the Office of Workers' Compensation Programs, and the Office of Labor Management Standards. In addition, she has served in Capitol Hill as Workplace Policy Counsel to the Committee on Education and Workforce in the U.S. House of Representatives. She also served as in-house counsel for labor employment matters to the U.S. Postal Service for 6 years. She also served as on the staff of U.S. Secretary of Commerce Malcolm Valdez, and she was even of counsel to the law firm Safe Offshore LLP in its Washington, D.C. office. So she's had quite an extensive experience, and we know that she'll be able to give us quite a bit of wisdom. Joining us as facilitators is John Hamlin, who is Chief Counsel, Employment Benefits and Governance Planning Companies in New York, Gwen Wilcox, who is a partner at Levy Radner representing Union, and William Frumpkin, who's at Frumpkin and Hunter representing the plaintiff bar. As I said before, my name is Daryl Gay. I am a partner at Aaron Fox. We represent management. Having said that, Commissioner Lipnic, please convey us some wisdom.
Great. Thanks so much, Daryl, for inviting me. Thanks to my colleagues as part of the panel today. And many thanks to the College of Labor and Employment Lawyers for the sessions that you're doing. I should say at the outset, I'm not actually a member of the College of Labor and Employment Lawyers. However, I have written many recommendations for people over the years to become members of the College of Labor and Employment Lawyers. So I'm glad to be with you. I'll mention a couple things just sort of broadly about the EEOC before we get into what I know people have so many questions about the coronavirus situation, but just a couple of things. First of all, this year, in case people probably have not focused on it, but we certainly have at the EEOC, this summer, actually, July, is now the 55th anniversary of the EEOC opening its doors. So, you know, quite an extensive history in terms of the EEOC's work and development of the law over the past 55 years. Not the least of which I do want to mention the Bostock decision out of the Supreme Court this summer, which certainly had many people participating in bringing that case to the Supreme Court. But I do want to give a shout out to my colleagues at the EEOC, all of our appellate lawyers, our litigators who worked on so many of the cases, particularly over the last decade. And I would be remiss if I did not mention my former colleague on the commission, former Commissioner Feldblum, and all of her work as an advocate for LGBT rights. But that was quite an achievement, I think, this summer with that decision by the Supreme Court. There have been a couple other Supreme Court decisions of note. One for people who care about age discrimination, which is something that I've focused on a fair amount in my tenure at the Commission. That was the Bev v. Wilkie case, which was a federal sector decision about the statute and the age provisions under the federal sector. That was certainly, I think, a victory for people who want to make sure that they, in the federal sector, can have their age discrimination cases go forward. And then also, this is kind of a, not really so much the EEOC's area, but yesterday, for all of the labor and employment lawyers, the NLRB issued their decision in the General Motors case, which has to do with issues about disciplining employees who may have been spewing racist comments or a lot of nasty comments at whether their employer or in the work site. And there was some tension there for quite some time between the National Labor Relations Act and, at least from my perspective, for the EEOC, the enforcement of the discrimination laws. And that was a case that we filed a brief in. We, the EEOC, filed a brief with the National Labor Relations Board. And a lot of that came out of the work of our task force on harassment. And there had been suggestions by our committee members, our task force members, that there should be some better alignment between the National Labor Relations Board and Title VII and actions that employers want to take to ensure that they have workplaces that are free from harassment. So that just yesterday, that the board issued that decision. A couple other things just quickly I'll mention. In terms of sort of operationally, I know that the EEOC has been in a, we have been in a full-time telework mode nationwide since I think it was March 13th, pretty much like many other employers in the country. And we are still in that mode. We, like other employers, have our own internal COVID-19 task force that is looking at our operational issues. And there's a plan in terms of bringing employees back that would be a phased plan, but we have not entered even phase one yet. Probably we're closer to it a few weeks ago before, like everyone else, having to address the situation as it develops with the pandemic. Might have entered phase one a few weeks ago, but we're not in that situation now, and that is across the country. And so our offices, though, are open for business, and people are teleworking. We have some early on. There were early on in coronavirus times, I should say, not to be confused with the before times. So we made a decision that in terms of case closures, that we would hold those because, of course, March, April, there was a lot of uncertainty about if people got a notice of their case closing, would they be able to get a lawyer if they and then shortly thereafter, we also received some letters and requests from a number of the civil rights interest groups, the National Women's Law Center, Leadership Conference on Civil Rights, asking us to do just that, to hold right to sue letters and to hold case closures. So that was, March, April. Well, now here we are approaching the end of July, and there's a lot of internal discussion about not wanting what we're going to have to do to address what will become and a backlog situation of the cases being closed. And so that's something that's very much on the front and center in the leadership in terms of what to do to address that situation, and trying to find the right answer there. But as you've seen, like I mentioned, the EEOC is open for business, and all the usual things in terms of taking in charges, conducting investigations, all in changed times, of course. We're not doing, on-site investigations, but telephones work, Zoom calls work. And and I'm happy to talk a little bit more about this later, but also our chair, Janet Dillon, recently announced a pilot conciliations program to make a couple of, to incentivize the conciliations a little bit more, and also our mediations program, and to allow more of our charges, when people first file charges, more of those to go to mediation. So I think many people probably on this call are familiar with when someone files a charge with the EEOC, the charges get categorized as an A charge, a B charge, a C charge. C charges, generally there's not much there, and those will be dismissed pretty quickly. B charges, not entirely sure, want to get some more information. A charges, probably pretty obvious that likely that there's been some discrimination. And then there are also SA charges, which are those priority issues that the commission is particularly interested in. So for a long time, the LGBT charges fell into the SA charge category. So the mediation pilot, and when someone would file a charge, then certain cases would automatically go to have an offer of mediation, that the EEOC would conduct the mediation. Those it would generally exclude SA charges or A charges. The mediation pilot will now allow for possible mediation of those A charges or SA charges, and then also allow for mediation a little bit further into the process. So it doesn't have to be just sort of a one-time event offered up front before there's been any investigation. And I should also make sure I say that, and of course, mediation is always voluntary. So, both on the part of the charging party and then on the part of the employer, the mediation program has been over 20 years now, very successful at the EEOC. But it would be nice if there were a greater take-up rate, and I've said this for years, by employers. So the take-up rate by employers is, I think, about 20%. And so, part of the goal is to see if we can get more take-up by employers. So anyway, those are, and last thing I'll mention, sort of the segue to, I guess, our topic du jour is July is also the 30th anniversary now of the Americans with Disabilities Act. I think anyone who practices in the labor and employment area certainly knows the really profound impact the ADA has had on workplaces around the country, and just a complete reorientation to people about their thinking about how to accommodate people and make accommodations available for people with disabilities. So we should all next week be celebrating the 30th anniversary of the ADA. So with that, if that's sufficient for you, Daryl, I'll turn it back over to you.
Thank you very much, Commissioner. In fact, if I may note, the Commissioner did indicate to us that to the degree anybody had any comments or concerns about the operations of the EEOC, she'd like to hear those. So among your questions or features you want to send via chat, feel free to list that as well. So we're going to turn now to the topic of testing, and I'm going to let John start us off with the broad question.
Sure. Thank you, Daryl, and thank you, Commissioner Lipnic, for the opportunity to discuss these important issues. This has been really an unprecedented time for employers and a challenging time for employers. And there are a number of issues that it'll be great to speak with you about today. And one question I had is sort of related to the EEOC has put out some revised guidance, but I'm wondering if you could comment on the circumstances under which employers are permitted to mandate that employees be tested for COVID-19 before returning to work. In particular, the diagnostic tests, but also comments, if you have comments on antibody tests as well.
Sure. So a couple of things. First of all, I did want to mention that, and I know this was due to a lot of the reporting about the information that the EEOC put out, but our legal counsel's office, and kudos to all the folks in the legal counsel's office who worked on the guidance, which people, that's on our website. There's, and that's in the form of a what you should know questions and answers. There's also a document that dates back to 2009, since updated, having to do with pandemics, and that was actually created during the 2009 H1N1 situation, a piker in comparison to today's situation. And there's also, early on, there was a webinar that was done by Carol Miaskoff, our Associate Legal Counsel, and Jean Goldberg and Sharon Renard, who are two of legal counsel's experts on the ADA. And so both that webinar is available on our website, and then there's also the transcript of the webinar itself. One of the things that the legal counsel's office wanted to make sure that I mentioned is that, so those documents available on our website, which some of the press reporting said, well, the revised guidance, but it's actually, the guidance is updated on a regular basis. So the questions themselves haven't actually been revised so much as they're just new questions and answers that are added to it, as, of course, you know, we get questions all the time. And there's a date by which we are adding those questions. So, so to your question in particular, John, of course, the ADA requires that any mandatory medical test of employees has to be job related and consistent with business necessity. And so you apply that standard to the current circumstances of the COVID-19 pandemic. Employers can take steps to ensure that employees entering their workplaces to determine if they have COVID-19. And the reason they can do that is because those employees would potentially pose a direct threat to the health of other employees. So if an employer wants to administer a COVID-19 testing, which is again just the test to determine if someone has COVID-19, they can do that. Now, one of the things we've also said is that employers want to make sure that the test is the tests that they're using are accurate and reliable. And I know the CDC has put out a fair amount of information, and I think also the Food and Drug Administration about safe and accurate testing. So that's something employers really should be keeping up on, not just what the EEOC is saying. And of course, we're consulting that information on those agencies all the time, but the employer should be consulting those also. And then, you know, I mean, obviously, all of the types of safety protocols that employers want to have in place, and I know lots of people are giving a lot of thought to, again, the EEOC itself as an employer. So whether it's the social distancing and regular hand washing, and whether it's having more space between where employees actually work in their workplace, anything, those kinds of steps to prevent transmission, that's something that employers are certainly able to do and certainly encouraged to do. Your question, though, as to antibody testing. So, I mean, that's a different situation, and at least in light of the CDC's interim guidelines, where they said that antibody tests should not be used to make decisions about returning persons to the workplace. Our view is that an antibody test at this time does not meet the ADA's job-related and consistent with business necessity standard. So, and you know, of course, the antibody test is different from the COVID-19 test but that's at least that's our current position and based on the current science.
Commissioner, quick question for you. If a person, a company or employer uses a test that's not been approved by the CDC, would that be viewed as an invalid test, or would that create an issue for the EEOC?
Well, I guess it would depend on, what's the information about the test and who's made the determination that it's invalid, right? So I guess if there was sort of some glaring thing from the Food and Drug Administration or the CDC that, Joe Schmo testing company is not to be trusted, that would certainly give us pause. But I guess it would really determine sort of what's the information about the test that is somehow demonstrating or claiming that it's invalid. But employers obviously should look to reliable sources. So.
And I would assume that as test capability and reliability changes, the EEOC's guidance on that may change as well.
Yes, that's correct. And thank you for mentioning that, John. And our, legal counsel's office is in, discussions and regular contact with the CDC. And so, yes, the answer to your question, which is why certainly, consulting, on a fairly regular basis, what questions that we have answered and put up and addressed is something that employers should do.
Hi, good morning, Commissioner Lipnic. This is Bill Frumpkin, as mentioned, and I'm sure Gwen would agree with me that, from the worker side, we have people that have lost their jobs, people are telecommuting, and some people have to go to work, and putting their lives on the line, the least of which are healthcare workers. So we really appreciate your time today. Now, continuing on the testing question, is there any guidance about whether employers can just choose, to test certain workers as opposed to others, for example, by a specific department, or maybe even more controversially, well, let's say individuals over 65 who have been judged to be a risk factor?
Right. So starting with the age issue first, we do have an Age Discrimination in Employment Act, and so singling out workers based on their age is not something that employers should be doing, even though, and you're correct, right, if you look on the CDC, some of the CDC information, right, they list their high-risk employees, right, and so those over age 65, pregnant employees, but that is not something in terms of age that employers should be singling them out, just because they think that they are higher risk. Now, employers certainly can and should think about, asking, particularly as they want to bring employees back, whether anyone needs a reasonable accommodation. And, they can ask that generally, not on an age-specific basis. And that's something that, I think there probably should be a lot of employers asking that question and trying to determine if any of their workers need accommodations. That, you could have all kinds of people who have underlying health conditions, and they could be, 35 years old and need some type of accommodation. So, not just based on the what the CDC has said in terms of high risk employees, but employers could ask that generally. Now, in terms of testing a particular part of the workplace as opposed to all of the workplaces, some of that, of course, depends on, well, is there some greater risk, right, for the particular work site that employers want to test for? But of course, I keep saying this over and over again, Title VII and all of the federal workplace discrimination laws have not been suspended in light of coronavirus. So employers would want to be careful about are the only people they're testing, you know, all of the African-American employees who happen to work in a particular area of the workplace. So a lot of it should be based on, you know, doing the risk assessment, but I think employers have to be cautious about how they're going about it and deciding who they're testing. And in particular, you know, if they're only testing sort of one group and not testing others, particularly, again, when they're bringing people back to their workplace and they're going to have the, people are going to have the interaction with each other that they had in their workplaces before coronavirus, in the before times.
Thank you.
So Commissioner Lipnic, it's really my pleasure to be part of this panel and really to hear your insights of what's and how EEOC is dealing with the pandemic. And certainly I represent unions and employees, and as Bill mentioned, you know, healthcare workers really have been in the front line. So these issues are front and center for all of us. So I have a question, Billy, you know, again, on the testing issue. And the question is whether an employer can ask an employee, have they been tested for COVID? And also, are they required, and can they request the results, and are they required to get the results once they have made that inquiry?
And are you, when you say, when they are asking about the results, is that for the employer to get the results of it, or
Yeah.
So for the employee to disclose the results of it to
right, so when the employer is asking an employee, have they been tested? So this would be really in a situation where maybe the employer is not actually testing its employees, but somehow becomes aware that an employee has been tested or wants to inquire whether an employee has been tested. Can they ask the question, and are they required, is the employee required to give the results, or is it just voluntary?
Well, so in terms of can the employer ask, yes, they can ask, and I think that's one of the answers that we have on our what you should know questions and answers under the disability related inquiries and medical exams, which, so, you know, asking that would fall into that category. It's also, you know, employers can also ask about symptoms as well. But if, I mean, employers are going to want to know the what the result was, right? So it doesn't do much good if you just ask, have you been tested? And then you don't get, then all you get is, yes, I've been tested, but you don't know what the result is. Because the employer is going to have to make some determination about whether or not, if the employee would say, yes, I've been tested, and yes, I tested positive. And again, as John said earlier, I mean, all of this sort of is developing as the science is developing, right? So I'm not sure right now. I'd sort of want to consult the CDC guidance about what if someone says I was tested 2 weeks ago, right? So how long are the results good for? Or if they said I tested positive 3 weeks ago, you know, the timing of all of that is certainly relevant to the determination that the employer is going to want to make about whether they would need to exclude that person from the workplace.
Thank you.
And you know, to follow up on that, I mean, one part of it is asking about the test, another part is getting the results. And, you know, the sort of third part of it is what you do with the results. And, you know, I know that one of the questions that has come up is really whether an employer can ever confirm that an employee has tested positive for COVID-19, and whether an employer can disclose that to an employee, a coworker who may be concerned about a fellow coworker, or even to a union if the union is concerned and is asking, under what circumstances can an employer disclose the result of a positive COVID-19 test?
Well, certainly, the information about the test is confidential medical information, and whether or not the employee has tested positive or had the test at all, and that should all be treated as confidential medical information in the same way that an employer would treat other information about other medical information. So, everything from keeping the information in a separate file, the people who should have that information and know that information should only be on a need-to-know basis. I would hope that many employers now are already thinking through, and certainly, a lot of employees probably have started, those who have been teleworking. And to Gwen's point earlier, I certainly want to emphasize that I think it's 25% of the workforce has been teleworking, right? Only about 25%. So as much as, for example, our call today, or we like to think that, the whole world has been working from home, that's really, not the case. It's only been a percentage of the workforce that's been working from home. Anyway, but the information should be treated as confidential medical information, and in terms of disclosing it to other people in the workplace, not any different than any other medical information, like only on a need-to-know basis. The idea of disclosing it to coworkers, that certainly doesn't have to be the case. Employers should certainly think about, they can certainly disclose to other coworkers, well, you may have been exposed, but they don't have to, if you think about it, in many situations, employers don't have to disclose who exactly is the coworker who might have tested positive for COVID-19. So, and what I started to say earlier is, I think that employers should be thinking through now, well, who are the people who need to know the information, right? And that they have some kind of plan in place for that, and that they are thinking about who are the supervisors who need to know, and really get a handle on how they're going to deal with that information that they both want to have and need to have to keep their workplaces safe.
Commissioner, aren't there two exceptions to that? Two examples I give example. One is if the Department of Health wants to be information about a person being confirmed as having tested, so they can do contact trace tracing.
Yeah.
Second thing is if you're using an agency to provide employees to you, and one of the employees who the agency provides to you tests positive, aren't they obligated, and don't you have a right as an employee to be told by the agency that one of their contract employees, in fact, tested positive?
You're saying the agency being like a third-party agency that's doing hiring, or
providing employees. You're bringing in temporary employees or working, helping out, something like that.
Right. And so the situation being that the third-party agency would be providing the information about someone who tested positive to the employer or to other employees?
To the employer.
Well, I'm sure. I think the employer would want to, yes, as part of their arrangement with the third-party hiring organization, want to know that information. And so, but again, that I think would still fall into the category of need to know information. So I'm curious, though, you mentioned the situation also, and I saw John was nodding his head about the public health agencies, and have people had that experience already? And what's been the situation, and how has it unfolded?
Well, there may be agencies, in the U.S. or around the globe that will require you to report known cases, and so disclosing to a health agency that someone has tested positive may be required, although there may be other means for them to get that. I would assume that if an employee voluntarily allowed an employer to disclose this information, that would be permitted.
Wait, if an employee, did you say if an employee?
If an employee voluntarily allowed an employer to disclose to coworkers, please let so-and-so know that that I've tested positive because we were in close contact or whatever.
Sure, I would think that that's the case. I just want to make sure if I were the employer that I had some ability to document that or verify that after the fact, right? So that. But otherwise, yes, if the employee themselves is documenting it. I'm curious what Bill thinks of that one.
Well, I would think if the name of the person had to be given, and there might be a battle as to whether that was actually the case. It would seem to me that you certainly could let another agency know that there's been an employee that that has been tested or needs to be tested or whatever. But then disclosing the name, I think, gets a little dicey. So I think that would have to be the last part of it that would have to be stated. Mm-hmm. At least you can address the concern without mentioning the employee. Even if the employee didn't continue to work there, that wouldn't mean someone has necessarily had the virus.
Yeah, but the problem is that what I'm thinking about is if I'm contracting with an agency to provide employees either to my work site or to another location I'm responsible for, and this agency finds out that one of their employees they're assigning to me has tested positive, I need to know as an employer so I can put the employees I have on notice that there's a problem and manage, know whether or not the site might have had some exposure and need to sanitize the site. I need to know that. And I think from looking at your guidance, I thought it was that we were allowed to do that. Give notice, give information of that nature to the main primary employer.
Yes, I think that's the case. Yes.
Yeah. Certainly, confidentiality in the workplace of where they left could be maintained. And all I'm saying is from a plaintiff standpoint, or employee standpoint, you need to do it as carefully as possible and not be disclosed to meet that goal. You
don't need to disclose it to the other employees, but the employer itself needs to know and then use the confidentiality provisions to make sure that the security of the site is ensured.
Right.
Well, inquiring minds are always going to want to know, what's going on in the workplace, coworkers or whatever, and really the need to know this information. The information that's going to be useful to most coworkers is simply the fact that they were disclosed, that they were exposed, that somebody who they worked with has tested positive, and that they need to be tested, and that they need to make certain that they are aware of their own health and to monitor it.
Right, and then to use the example that John used, that is it okay for the employer to an employee who's positive once says to the employer, you can tell someone else. I mean, that is a problem as we're discussing, but doesn't preclude the employee to have the contact that person directly, so the employer is totally out of the picture, and you don't have to get into a question whether this was voluntary or whether they were pressured to tell someone. It's just to be employee to employee, and the employer is out of the picture.
But I think we all know, there is a gossip mill and a grapevine and all these other things, and
right.
You can do the best you can to protect against that, but people are people to some degree. But
let's move on, guys. We need to move on, guys.
And in some situations, it could be the particular workplace, right? There are only so many employees, so it's going to be pretty obvious, right, who the person was who was exposed. So, sorry, go ahead, Daryl.
I just continue to move along the agenda. I'm seeing a falling a little behind schedule.
This is a good segue into the next question, because there's a show called Fear Factor, okay? And so use the name of the show, although I've never watched it. Probably the number one question that people who represent employees get now is, when they start talking about these phases and return to work is, do I have to go back to work? I'm afraid to go back to work. I have this problem or that problem. I don't really feel like telling the employer why I don't want to go back to work, but I'm afraid. Do I have to go back to work if they make me go back to work? So what would the position the EEOC be on that?
Well, so the do I have to go back to work, right, would essentially be a request for an accommodation, assuming the person has been accommodated and working from home. And so, the employer should treat that in the same way they would treat any other request for a reasonable accommodation, and go through the same kind of analysis that they would there, asking questions to determine whether the condition is a disability. And of course that can include, any pre-existing mental health conditions, or, anxiety disorder or things like that. So, that's something that employers should take into account. I mean, I think that if the employee is going to say, I'm afraid, right, I don't want to go back to work, well, just like with any, again, sort of accommodation request, they're going to have to produce some information. And then when the employer starts inquiring, well, why is that the case? Or, I need some medical documentation to deal with that, the employee is going to have to provide that. So now, I think we've already opined that, these situations, employers may have to take or may want to take some interim action, right? So grant the extension of teleworking, or whatever the accommodation is, a little bit longer as they're, they're trying to deal with bringing people back and get whatever medical information that they need from the employee. The employer should be sort of taking into account the circumstances under which everybody is trying to operate now. So, sort of flipping the switch on, okay, everybody's back. Employers have to be ready to deal with these types of accommodation requests, even if they're not stated, right, as an accommodation request. So as you were saying, Bill, if someone says, I'm afraid to go back, or, people have post-traumatic stress over this. None of us know, right? People could have friends who have died from COVID-19, or family members who have been hospitalized, right? So as with any disability situation, they're all going to be so fact specific and so individualized, and employers should be both preparing for that and ready for that, but also, take into account, I think, the how to deal with it in an interim situation.
So to be clear, could develop a disability based on their fear of going back that could theoretically meet the guidelines of the ADA, and then the accommodation maybe to work from home if possible. Okay.
Right. They might not have had any kind of, anxiety disorder before coronavirus, but, now it's been brought on by that. But they will, again, have to document that if the employer wants that information in order to provide them an accommodation. John, you were going to say something.
Well, yeah. Before we move on to other topics, I just had one question about testing. Really quick one. There's been a lot in the news about developing vaccines. Everyone's very optimistic and hopeful about the development of a vaccine. There are already, a lot of chatter that you see about people never going to get a vaccine, not wanting to be vaccinated. Can an employer, once a safe and reliable vaccine is available, will an employer be able to require its employees to be vaccinated for COVID-19?
So I just want to be clear, we have not answered that question specifically yet. So I'll underline yet, because our legal counsel's office is, like I said, in consultation with the CDC. So, but it's certainly a question that is on our to-do list and horizon. So I would say people should, follow closely and see where we end up on that. So I don't want to speculate too much, but I would say just stay tuned on that one. The one thing I do want to mention, though, as in the case for any any other situation where the employer requires a vaccine, say in hospital settings, a particular type of vaccine, employers do have to entertain then requests for accommodations, whether that is a disability-related accommodation, so that can the vaccine be administered in some other fashion, or are there some other protocols that would be as effective, or religious accommodations. And we've certainly had those cases at the EEOC, at least in my time there, that where people have requested a religious accommodation related to the vaccine. So employers have to keep those things in mind.
So before I think we move from this area, I have a question, Commissioner. Can an employer justify an employee receiving accommodation by excusing them from being tested because of the fears and concerns of other employees? So it's another fear factor question.
Well, if the employee who's entering the worksite requests an alternative method of screening or something like that in terms of fear factor, again, you'd have to treat that as a reasonable accommodation. It seems, I think merely pointing to the fact that other employees are fearful that if the coworker doesn't follow the safety protocols, or if the coworker, let's say, has some alternative method of screening as an accommodation rather than, say, the COVID-19 testing, that would probably be insufficient to establish that the accommodation would oppose an undue hardship for the employer. Yeah, I think that's a tough question, but overall, I don't think the fear factor overall can exclude, right, an employee from the workplace. Again, I think the employer is going to have to drill down on that a little bit more about, well, is this a request for an accommodation, and can we, can it be medically justified, as we were talking about earlier, and then two, is there some type of accommodation that can be worked out? But the employer is probably going to have to drill down on that a little bit more. And I guess I would say likewise too, I recognize this is a little more difficult on the employee side, that employees aren't necessarily thinking, oh, I need an accommodation, right? They're just thinking, I'm afraid to go back to work. So to the extent that employees can be educated about understanding what you're really asking for is an accommodation here somehow. So, but overall, I think the employers have to really be cognizant of those situations for the employees.
So, Commissioner, one of the questions, I'm sorry, Gwen.
No, I was just going to say, just with all of this, communication is so key. It's not just the first thing someone says, but really to have a conversation and try to, as you say, to drill down to have a better understanding and understand what people's fears are and what are they communicating.
Right. And to your and communication, right, in a world where communication is really altered right now, right? So it takes even more effort.
Right.
So, Commissioner, one of the queries was if I need I'm afraid to return to work because I have elderly parents at home. That does not give someone a protection for an accommodation. Am I correct?
Correct.
So let me ask you a challenge. Go ahead, sorry.
No, I was just going to say, of course, there is such a thing as associational, right, discrimination under the ADA, but that's not, the situation that you just described.
Exactly. So let me ask you a question. So frequently employees are deciding how to deal with accommodations. They usually have to use the undue burden test. But this sounds like with the question of fear and religious objection to testing, the question might become, does an employee use the undue burden or the direct threat standard as determining whether or not they should or should not do something?
Well, I think that we've said for the most part in these situations right now, the direct threat standard is going to be met, right? So, if a direct threat is by definition a significant risk of substantial harm to the health or safety of the individual and others that cannot be eliminated by reasonable accommodation. So, you sort of come back around to, and then if it's the reasonable accommodation, right, the question is it an undue hardship? So, so I think it's, employers are wise to be taking into consideration what the undue hardship is and how they would justify that. But certainly, not just label everything as a direct threat, right? So, I mean, again, as much as possible, I think treating these things as if it's you would analyze it in the same way you would for any other kind of accommodation. But the direct threat is very real here. So, and that's something that we've talked about in our guidance document.
So let's move on to the mask right now and discuss the use of mask.
Yes, I was going to say the word mask is probably the most used word in any language right now. So we have to go into the mask thing. And so here's the question. If an employee doesn't want to wear a mask based on some either health issue, religious issue, or something along those lines, what is the EEOC's position on that situation?
Right. So, on the masks, first of all, I think employers should be treating them as they would any other type of safety equipment, right, in their workplaces. And if there's something and if they're required, then the employer, can certainly say, yes, this is what we want you to wear. But again, what you're asking about is, so then the employee is objecting for all kinds of reasons, right? Can I have an alternative, right? I can only wear a mask for 2 hours at a time, or I need to take a break. I can't wear a mask, but maybe they can wear, the plastic, the screens, right? So that people can, so it provides the same kind of protection, but people can see their face if there's some reason that someone needs to see their face. So, I mean, I think that employers have to explore, all of those kinds of alternatives. Overall, I think they can require the mask, but again, if they get these requests for, I can't wear one for whatever type of reason, medical reason, they can ask for the reason and they can try to come up with ways to make it workable for the employees.
Yeah, there seems to be a fair amount of resistance to masks throughout the country, and employers are certainly experiencing their share of resistance. But I guess, one of the tensions here is between the individual's concern about not wearing a mask, perhaps the accommodation that might be required to explore through the interactive process. But ultimately, what about other employees around them who are going to be, potentially concerned, panicked over their own health and their own safety as a result of it? Is that a factor that the EEOC would allow employers to consider when looking at this accommodation issue?
Yes. I mean, it's certainly something that I think that we would have to take into account. And, well, in the same way that there were any other type of, safety situation where in the workplace that the employees had to wear, particular safety equipment. So, sure.
Yeah, because I would imagine that, that those coworkers are going to view that employee as a risk to them, a direct threat to them, perhaps, as a result of that.
Yes.
Okay.
So let's move now to, when the clock is ticking away gracefully, let's move to the next big hurdle that employers and everyone's going to face as we get ready to start resuming operations. The question of telecommuting and what that means as it's been applied to date and what it's going to mean going back to work, how it might as we go back to work. So John, since that usually starts with an employer question, can I have you initiate the questions?
Sure. I think that that a lot of employers who, at the start of this, were trying to find ways to simply continue to operate and to continue to employ as many of their workers as possible, and moved to teleworking, remote working, as not necessarily an ideal choice, but as an option of necessity in order to be able to keep their operations running and to keep as many employees employed as possible. And so they have allowed employees, I know a number of employees have allowed workers to work remotely, maybe not doing all of their job duties, but a significant number of them. And I think there are some employees who may not be enjoying working remotely, but others who are, frankly, who are, certainly fans of remote working, having experienced it. And so let's suppose the pandemic ends, everyone is working, is asked to return to the office. Will the fact that the employee was permitted to work remotely in order to be able, to get through this pandemic, how is that going to factor into the reasonable accommodation undue hardship analysis? Is it sort of the notion that no good deed goes unpunished, that employers who have permitted remote working now may not be able to require work in the workplace once the pandemic is over?
Right. So, as you said, I think, obviously employers are really going to be confronting this issue because they really quickly, moved to that as quickly as possible to address, keeping people employed. So, as a general rule, right, the employer is not bound to continue allowing their employees to telework just because they did so as part of their response to the pandemic. So that would sort of, that would be the general rule. Now, again, the employer is going to have to consider and want to take into consideration. So, again, sort of asking generally, do people need a reasonable accommodation? If people ask, well, I'd like to continue teleworking. The same analysis that takes place in a situation pre-coronavirus times about teleworking, employers should go through. There's a pretty significant body of case law, certainly over the last 20 years, about teleworking, even over the last decade, and a lot of that has evolved as to issues about is being at work and at a particular work site an essential function of the job. And honestly, this is something that I went round and round with my former colleague, Commissioner Feldblum, about for many years. And you see the courts are pretty the federal courts have been pretty resistant to the idea that even though they're willing to address teleworking situations, but the idea that the employer in the first instance doesn't get to say, well, this is where I want my employees to do their job, right? Here's the work site. Having said that, employers certainly in the analysis, they never have to remove an essential function for a job. I think given the current situation, as many people have worked from home, employers should certainly be trying to get a good handle on, well, what are the essential functions of the job, right? So all of these, the cases, and particularly, certainly the case law on the teleworking cases, like any accommodation, but very specifically here, are so fact-bound. They are so specific to that particular employee's situation. And when employers are now going to be faced with likely, well, it's not just that people want to telework as an accommodation a few days a week, it's going to be requests for 100% telework, right? Mm-hmm. So employers should be really looking at what are the essential functions, what are the marginal functions. Maybe they have a different assessment of all of that now, than they would have had 4 months ago. Has the employer implemented some new technology that they think will overcome what are otherwise, for the most part, in office or in the particular workplace functions that the employer wants? I mean, the most obvious one is supervision, right? The other one is interaction with other employees. So these are so fact specific, but I think employers would be wise to be really thinking already about what are those essential functions, what are the marginal functions, have we implemented new technology, and do we think that new technology actually works for how we want people to be able to do the job, and certainly be thinking about those. But again, as a general rule, just because someone was teleworking, to keep the work going during the pandemic, doesn't give you just an automatic pass on, well, you get to telework going forward. So I'm curious, Bill, what you think on that.
Well, I was going to say, I was going to ask you the follow-up question, which is, sort of goes into what maybe an employee asked for an accommodation and was told that they couldn't have one, meaning to telework. Now they telework, hopefully successfully, and they say, well, okay, I just demonstrated to you that I can telework. It's obviously not an undue burden because I did it and no one was complaining about anything. So I would have to agree with you on the individual aspect of it, depending on the nature of the job. But I would think it does undermine the employer's position some after, you actually did it, and that I would think might make a judge feel a little more, I guess, welcome to the idea that it is reasonable.
Well, and to your point, Bill, just the operative word in what I heard you just say is successfully, right? Did the employee telecommute successfully? And when you look at all the cases on this, there's just so much, about, when the employee has made the request for teleworking, let's say, 4 days a week or full time, and if they have at some point telework, has it been successful? And there's a lot of determination that goes on about that.
I was going to say, would you find it advisable, Commissioner, that a employer, like I've told some of my clients, now before you have people going back to work, really do what you suggested, do the definition of essential marginal functions, analyzing going forward would be, but also defining, as you point out, a lot of companies skipped a couple point requirements of essential functions because of the nature of the pandemic and the urgency of it. I would say it's important to bring the employees' attention that you haven't been performing essential functions of the job because during this pandemic we've allowed it, but this is not going to be going forward. So that when they get, and even more so when they get the request afterwards, and they can't come back and say, we're only saying no now because of X, Y, and Z. I think it's advisable to add in those qualifiers, that this is what you're missing.
I agree. And the other thing, and I've been saying this for years, is in job descriptions, I think employers should be making it clear where they want the job to be done. And, because that's what you see in a lot of the case law is it's a lot of so it's both the performance kind of issues. And as Bill said, has the person been teleworking successfully? Then the other thing is that, a lot of the courts have dealt with is the on-site, right? Is it on-site attendance? That is a function of the job. And, employers don't make that clear necessarily when they hire someone. And that's something that I've been saying that for years, that employers ought to make that clear so that, when they are confronted with requests for telework, whether it's, in one-off situations or in the situations that we are in right now, where it's en masse, right? That they have some standards in place and they know what the expectations are and for their particular job and where they want the work to be done.
John, did you have a comment, John? Or
No, I mean, I think it's important for employers to continue to define what the essential functions of a position are, and also not to abdicate that responsibility to the employee who's performing those essential functions. I mean, that's really the tension here between the request and also the reason for the need. I mean, I think that the nature of the the request for the accommodation and the disability that is trying to be accommodated, I think, is an important part of this analysis as well. If there's another accommodation that could be reasonable under the circumstances apart from telework.
But I was just going to say, as a litigator, I'm sorry, the fact that you already had the accommodation and you successfully, and that may be an issue of fact, were able to work. I mean, it's not the same question that it would have been as if you never had the accommodation, which is what makes it pretty interesting and difficult for everyone to some degree. I'm sorry, Commissioner.
No, that's okay. I'm good. Oh, actually, the one thing I was going to mention, this goes to what Gwen said earlier about, and again, in terms of bringing people back from teleworking situations where the communication is really essential, right? So some employees may be thinking, well, I haven't done that function in months, right? And therefore it's not, not only is it not a marginal function, it's a non-existent function. Whereas the employer has been, counting the days or waiting till they can get somebody back because they want them to be performing whatever that particular function is, and they've just been keeping it suspended for a while.
Well, you're right there, Commissioner, because a lot of companies are going to revisit how they operate. That's why they need to redefine now how they convey it to the employees. But let's move on to some of the issues that employers and employees are going to face post the resumption of operations. So let's first look at some issues might come up on the ADA. Bill, you want to start us off?
Yeah, sure. So, if an employee comes back, they've already had, the COVID infection, and now they have a medical clearance. If the word got out that the employee had the illness, can the employer lawfully, isolate that employee to speak to the concern of the healthy employee?
And you said the employee has the clearance, right? Where they had clearance that they came back. Well, in that situation, I'd say probably not, given the employee who came back has the clearance. So that doesn't seem to me like a good idea for the employer to be isolating that employee who had it. Again, I mean, this is, assuming the employer is going to have all sorts of other protocols in place, including asking about, were you tested, did you test positive, or having some, testing regime in place in their own workplace. So, but isolating someone who had it, I don't think is a good idea.
Right. Well, let's just say that the employer felt that they needed to isolate, the employee. Okay, and the employee was isolated, and the employee had a problem with being isolated and they didn't lose any money or anything like that. Would that still be considered an adverse employment consequence that they could base a case on?
Well, I guess I'd say potentially it could be. I mean, they're being treated differently. I think the employer would have to have a pretty good reason for treating them differently. So if we're saying the only reason that the employer is treating them differently is that they had it before and now they're back, that seems to me a bit of a dicey proposition for the employer. But so that if the employer then did isolate that particular employee, that seems to be a bit of a dicey proposition, I think, for the employer to do that.
Could the employer say to the employee, I'm glad to have you back, but don't tell anybody you had the virus, to avoid that kind of like isolation and concern of co-employees?
But the employee is not otherwise isolated. It's just don't ask, don't tell. It's a different version of don't ask, don't tell.
Could you discipline the employee if they spread the word that they just came back from the virus and the employee already told them, like, don't say anything so I can avoid all of these headaches?
So the employer's asking the employee, don't tell people that you had it.
I didn't even know you could do that. I'm just wondering if you could. This is the human nature component of life.
Yeah, right. Well, I guess the employer could ask that, but seems to me that's a little puts the employee in a difficult situation. And if the employee wants to disclose that, right, that's the employee can certainly do that.
I mean, it would seem like that's the employee's information to disclose.
Right.
I mean, I would advise my client if they were coming back, and they weren't looking for anything. I can't see what's to be gained from spreading that around. Some of this reminds me in the AIDS, HIV era, similar things where people, they were afraid to say they had something because of the problem. But then on the other hand, you had people that wore it as a badge of courage, so it creates all kinds of problems. So that was where that was the basis of the question.
Right.
Well, yeah, it seems like it would have the employer would have to have had some type of medical basis to be able to isolate the person, because if they were recovered, why would they otherwise isolate them? There would have to be some other medical basis to do that. Which, if you're recovered, you're recovered. You have a doctor's note saying you're fine to return to work. But I
mean, I guess the one thing that we don't know right now, right? So, so this is the as the science develops kinds of thing is, we learn every day more and more about the transmission, right, and how it's transmitted, right? So, I guess that would be the one thing for certainly the employers want to take that into account and be, if there's some other understanding about how things are transmitted. If the only way to bring the employee back is to isolate them because of having to protect other employees, then I'd at least want to make sure that as the employer that was based on some sound science.
Right, because we know that there are people who are asymptomatic, but doctors, we don't have any medical, no one has said how do you determine whether someone actually has the virus if they haven't, if they could still be tested and still test negative for the virus, even though they may be a carrier. But I know we're time is slipping away here. I just wanted to ask a question about if someone is a high-risk individual as defined by the CDC, is that a sufficient basis to have them be part of a protected class? If so, whether their requests for accommodations would be deemed to be protected activity.
Well, again, who and what the CDC has said are high risk employees. So, for example, a pregnant employee. Right. Employers should not be excluding people from the workplace just based on how the CDC has identified them as potentially high-risk employees. I mean, so both in terms of if the employer has some particular knowledge about one employee that they know, maybe, if they know someone is pregnant, I mean, the employer shouldn't on their own try to be paternalistic about this and be excluding people from the workplace. They should, be asking generally, who needs do people need an accommodation, or, do you need something to come back to the workplace? But they shouldn't be excluding people based on those potential risk factors, whether they're categorized by the CDC as high risk.
Keep in mind, everybody, that when you're listening to this, that's true under the federal law, but in certain jurisdictions, COVID-19 is deemed to be covered, such as New York City human rights law. Commissioner, could you spend a few minutes now just kind of sharing with us to the degree you and your fellow commissioners and members of the agency have been anticipating, what charges you're anticipating when they a religious discrimination, age discrimination, national origin, race? What are you guys thinking is about to roll down the hill and confront all of us?
Yes. Well, certainly everything we've been talking about here, right, in terms of potential, every flavor of disability discrimination, right? There's obviously the potential there. And keep in mind, right, whether on an individual basis or even on a potential class basis. So in any of these situations, all of the other aspects of Title VII and protected classes, right? So race, national origin, sex, pregnancy, as we just talked about. I think those are all things that we're certainly on the watch for. I wish I could tell you, and we just don't have the information right now in terms of, here's sort of the trends we're seeing, because, we're trying to assess things as we go. And also we're sort of into the time of year, right, July, August, September, where we're now into the last quarter of our fiscal year. And so that's when, we're starting to really, to make a bad pun, take the temperature of the agency and see what our charges look like and what cases will get filed by the end of the year. But I think on any of these bases, like I said, race, national origin. I mean, the national origin was something that early on, Janet Dillon, as chair, put a statement out about to remind people of the national origin discrimination we saw, after 9/11. Concerns here, particularly for Asian Americans, because of where the where the virus originated. So I think all of those things. And also I did want to mention also, I mean, given so much concern about racial issues and so front and center in the country right now, and I did go back and take a look at what our statistics looked like over the last decade in terms of race cases and charges. And as I mentioned at the beginning, this is the 55th anniversary of the EEOC. From the very beginning, right, the agency was really inundated with a lot of race cases. And for the most part, if you go back, the last 25 years, race charges and cases have made up about 1/3 of all of the charges that the EEOC would receive on an annual basis, until about a decade ago, when retaliation sort of took over as the main charge that people now file with the EEOC. But it is still the case that there about 1/3 of our charges are race-based, and I actually then looked at that a little bit further. And by and large, those things are either hostile work environment or harassment cases. And I've said for many years, certainly in my time at the EEOC, there is plenty of good old-fashioned discrimination to go around. And, we see it in our workplaces. And but, as the coronavirus situation has certainly exposed, and this may be the case. So again, back to your question, Daryl, that, what people are doing, what jobs in workplaces, and how employers are bringing them back to work, or if they've continued to work, or if they are more potentially exposed to safety issues. All of those things can ultimately get reflected in EEOC charges. I can't tell you that we've seen that yet, but I just think we're in just such we're just not in the time yet that we can do an assessment on that.
Before we proceed, let me give everybody the CLE code. It is SS0995. Once again, the code for CLE credit is SS0995. As I pointed out earlier, if you go on to the handouts, we do have a CLE form, and if anyone can't find that form, or have concerns or questions about getting CLE credit, please feel free to reach out to Susan Wan in the college office, and she'll be glad to help you. Having said that, let's proceed. John, why don't you discuss the question regarding operations?
Sure. Maybe bringing it back to something that you started out exploring at the beginning of our session, Commissioner, which is really the modified mediation program and any modified investigation protocols in light of COVID-19. What sort of changes, enhancements are you anticipating through this conciliation pilot program? Are there, the mediation process is going to be expanded, but what additional charges might be included in that? I'm not certain exactly if there's a change in the length of time during which employers can seek mediation. I'm hoping that you can shed some more light on that, because my sense is that a number of folks may be interested in hearing more about that.
Sure. So, well, a couple things. So first of all, just to make the distinction between the mediation, right, and conciliations, right? So the conciliations are once there's been a cause finding, and then we're in the conciliation mode. So on the mediation side, right, so that's when, someone files the charge, and we would ask, before there's any investigation, do the parties want to engage in mediation? And again, traditionally, there were any number of charges, types of charges that would get excluded from that initial offer of mediation. So again, those charges categorized as A charges or SA charges. Again, SA charges being priority issues for the commission, A charges being ones where it's, at least relatively obvious to the EEOC that it looks like there's been some discrimination. So the first part of the mediation pilot is to open up more types of charges to that initial offer of mediation and ask the parties if they are interested in mediating. So, and again, as I said earlier, the mediation is voluntary, so it has to be both the employer and the employee who agree to the mediation. And as I said, I hope it's the case that more employers will take us up on the mediation offer. And we have, just like our call today, made arrangements so that people will be able to do mediations remotely. And, I'm sure many of you have already done, whether it's, in federal cases in court or other mediations and things remotely. So I'm certainly interested in people's comments on that and how they think that's been going, whether it's with EEOC or some other type of mediation. So, the ability to do them remotely, more types of charges, and then so there's always that initial offer of mediation, and then if that is unsuccessful, then what traditionally happens then is we proceed to the investigation. So the other part of the mediation pilot is to, along the way, right, once we've already started the investigation, then offer mediation at other steps along the way, up until we get to the conciliation, because again, conciliation is only after once there's been a cause finding. So that's the initial thrust of the mediation pilot, to make it available for more types of charges where we traditionally would not have done so. And then to make it available more throughout the whole process. And as you know, I'm certainly, as many of you, I'm sure have experienced, investigations, right, can take quite some time. And we would entertain, maybe an investigation has started. I mean, I've certainly heard this for many years. Once an investigation has started, well, maybe then the employer decides, once they get a little more information, that, oh, well, maybe they would like to mediate this. Now they've decided. At first, they didn't want to have anything to do with it, but now maybe they think they do. So certainly people should, make their interest in mediation once an investigation has started, and before it's concluded, make that interest known to the commission. And then for conciliation purposes, this is something that I've been interested in for a long time. And so the conciliations pilot then is, so remember, conciliations now we're into a cause finding, right? So the commission has made a cause determination, and per our statute, we are trying to get a resolution that is satisfactory to the commission. And so the goal of the conciliations pilot is to make more conciliations, extend, have the time period where once a demand is made, and of course it's the commission that's making the demand once there's been a cause finding. So have a good explanation of what the demand is about. Also to have some more emphasis on what we would call predetermination interviews, so that, sort of at the last point of before there's going to be a conciliation, a cause finding, make sure that there's an interview conducted with the employer, so that they understand sort of, where the EEOC is coming from, and have if they don't to the extent already, right? Because the conciliations, by that stage, we're pretty far into the process, but nevertheless, wanting to make sure that the employers understand where the EEOC is coming from, and have that predetermination interview, and then, try to resolve more of our cause, where we found cause, through conciliation. So post the mock mining decision, that was the Supreme Court's decision about conciliations, and I mean the issue in the case that the Supreme Court decided was whether or not the conciliation process was judicially reviewable. And so this is what, in 2015, I think, the Supreme Court case. And of course, the court said, yes, of course, it's judicially reviewable. And here's, the information that generally that a court should look at as to what has transpired in the conciliation, and which wasn't a whole lot. This is to try to put more standards internally, I think, in place for what our district offices do and have to provide to the employer to try to resolve things through conciliation. Our successful conciliation rate is, I want to say last year, close to 40%. After mock, it had for a long time it had hovered around, the maybe 35%, something like that. It's been up to about 41% over the past over the past probably 5 years. And so the idea being to for us to be more transparent and to try to have more things resolved in conciliation. So, and again, on the mediation front, where we have, again, for those who participate, the EEOC has a very successful mediation rate in the 90% range, again, for those who participate. So hopefully more people will take us up on the offer, and we're offering more opportunities for mediation earlier on the kinds of charges where we would not have traditionally offered that in the past. And then secondly, offering more opportunities for mediation even as the investigation is unfolding.
Oh,
Do you want to?
Daryl, you're on mute.
Sorry about that. Yeah, I saw that. Commissioner, before we wrap up, just want to go back again to possible claims you might be seeing coming down. One of the realities we're seeing is that very frequently the people who've been asked to return to work at this point or continue working during this period are people of color, which obviously creates a potential disparate impact factor. To the degree that a lot of that might be based upon the job they have or based upon seniority as defense or merit, has the EEO considered how it's looking to approach those challenges as they come down the line as cases being filed by guys like Bill Frumpkin and Gwen Wilcox?
I don't have one lined up yet, but I'm always looking.
Just trying to help your business, Bill and Gwen.
Right. Well, I think so. One, certainly the awareness of it, right? I mean, that's the reality. And two, I think the potential for, as I said earlier, either class cases or if there's something policy related, systemic cases. So that's something that we'll certainly be on the lookout for, or pattern or practice cases as distinct from a class case. So.
Well, thank you. Commissioner, before we wrap up, is any pearls of wisdom you want to share with us before we wrap this thing up?
I'm going to go back to what Gwen said earlier. So this is the second time I've mentioned it, but I'll endorse it again. Lots of communication, I think, is important, between employers and their employees right now in terms of expectations about, the work and to the best that people can assure their employees about, trying to anticipate, what will come in terms of their workplaces and their work, I think is pretty important right now, as this is all unfolding.
Well, thank you. I want to remind everybody again that the code for CLE credit is SS0995. Once again, SS0995. If you have any questions or concerns, you can reach out to Susan Wan in the college office. I want to thank you, Commissioner Lipnic, for all your help and involvement in this program, and thank Gwen Wilcox, William Frumpkin, and John Hamlin for participation. Remind everybody we have a program next Tuesday on virtual arbitrations. I hope you guys can join us for that. Everyone stay safe and healthy. Thank you so much.
Thank you.
Thank you.
Thank you.